You are about to listen to a free conference brought to you by LawSure Insurance Brokers, the award-winning specialist broker for title insurance. This conference is presented by Richard Snape, a leading speaker in all things conveyancing. Thanks for joining us. For those of you who don't currently work with us at LawSure, we are able to provide this essential free CPD support thanks to our amazing clients. Using LawSure to obtain your title insurance quotes instead of you having to go to multiple providers yourself means that you can save time and money. We make it easy for you. We have relationships with all the title insurance providers in the market, and as part of the Clear Group, we now also have chartered insurance broker status, meaning you have even more comfort that you're providing the right insurance solution for your client. Our team of specialist expert brokers are on hand by phone, email, or via web chat to help you and discuss the insurance options available. And our service is totally free for conveyancing professionals. That's right, it won't cost you a penny to use us. More information about us can be found on our website at lawsureinsurance.co.uk. There's a comprehensive set of notes to accompany this conference available to download for free on our website. So sit back, relax, and enjoy the conference.
Okay, thanks. Yes, it's repairs and service charge and a bit of building safety. I'm contractually obliged to mention the Building Safety Act at some stage during any day's course. It's not too much towards the end on building safety. There's a lot of cases. It's very much case law based, this, and I'm not going to plod through every last case. But I have to say before we start, obviously do ask questions in the chat throughout. But of all the common covenants you get in commercial leases, I think the one that is probably the most detrimental for tenants, and they enter into obligations they shouldn't be entering into, is the repairing covenants. You know, when people on short-term 54 Act excluded leases, somewhere as we speak, somebody on one of those leases is entering into a full repairing obligation. And unfortunately, they don't tend to think about it too much at the beginning, but they do tend to think about it at the end when they get a huge schedule of dilapidations against them. Yeah, and it's a matter of protecting your back, really. The worst one I've ever seen, and repairing covenants that don't really bear any relation to the property involved. The worst I ever saw was a few years ago now, in Hampshire. It was 57-page lease for car parking spaces. There wasn't a single building on it. And it had wonderful repairing covenants, had wonderful covenants left, right, and centre. But the repairing covenants included you had to maintain the electrical wiring of your car parking spaces. You had to paint your car parking spaces with oil-based paints. And my personal favourite, which I'm tempted to keep, is you had to yield your car parking spaces up at the end of the lease with new carpets. I think I'd stipulate a maximum fee to the carpets. I've seen an oil storage tank, a huge oil storage tank in Hampshire as well, actually, where they had to yield up with new carpets, their oil storage tank, and sand down the banister. So sometimes you have to think about these things. First point on interpretation, if you're dealing with, well, not just new builds, some of the cases are inherent defects from 60 years ago. But if it's an inherently defective building, that includes things like design defects and construction defects, it won't come within a normal repairing covenant. You can actually make people liable for inherent defects. And we'll come across that in relation to service charges, but it's not within the normal sort of liability. And I'll mention Quick and Taff Family Borough Council. It's actually a residential case. There's a few residential cases here. Just going to put myself on gallery view.
Matt, do you know how I
Somebody's unmuted themselves.
Things? Yeah.
Make sure you're muted, please. It's a residential case. It's council housing. The only real difference should be, although there are sort of policy considerations, the only real difference between short-term leasehold dwellings of less than 7 years duration and commercial premises and the likes, or long leasehold flats for that matter, is that the landlord's got to be responsible for the repair and maintenance of the structure and exterior and the installations. So mentioned a bit later on, it's section 11 of the 85 Landlord and Tenant Act. But in quick and taffily, just to illustrate the point, and we'll look at a commercial example. Some of these cases are not easy to reconcile, you have to say. But they had a badly designed council house from day one. It was the windows. They were sort of metal windows set in window frames, not metal windows. That would be foolish. Window frames set in concrete, and there was no sort of breathing. There was no ventilation. They didn't have chimneys and this kind of stuff. And again, make sure and it was causing huge amounts of condensation, and the tenants wanted to do something about it. The landlord's going to be responsible in this case, and the court decided it's inherently defective. It's a bad design. That's not within a general repairing covenant. And you've got a commercial. I like that one. A covenant that tenants and opticians should not make a public spectacle. I do like that. I'll be using that. That'll be featuring on LinkedIn later on. In the post office case, which is one of the classic cases, Aquarius Properties, it was the post office were a tenant under something like a 25-year lease. It was a late 1960s build. And it illustrates the point nicely, actually. It was a badly designed post office. I don't know if there's any other. In that there was, it was in the basement, so there was a joint, kicking joint as they're called, which was defective, with the consequence that when the water table was high, then it would basically flood, and it was unusable. And the tenant was responsible for repair and maintenance, and the landlord wanted to do something about it. The cost, bearing in mind it's the 1980s, the case, the cost, depending on which experts you believed, would be between 86 and 175,000 pounds. And in that particular case, the court decided that it's inherently defective again. It's been badly designed or constructed. In this case, from day one, it doesn't come within a repairing obligation. There's nothing stopping you sort of making clear the tenant is responsible for inherent defects, but that would be a pretty, outrageous thing to see in an individual lease. It also misses the point. People have a kind of quaint notion that if I'm not responsible, the landlord must be, or vice versa. Truth of the matter, if it's badly designed, is that nobody's responsible unless it's dealt with in the actual lease itself. And if it's a short-term excluded lease from the 54 Act excluded, the landlord's going to have to do something about it. They'll have to protect their reversion. If it's a 25-year lease, I think this was, then the tenant's still going to be paying rent for the next 25 years, subject to breaks and the likes, for a basement that's of no use to them. And you should really have surveys and the likes to deal with these things at the beginning. That's not easy if it's a new build when you enter into the property, into the lease, which it was here. How can you pin down liability for inherent defects? It's not an easy one. We've got that City of London Great Arthur House Court of Appeal case from not so long ago at the bottom of the page. But I'll mention Elmcroft and Tankersley Sawyer. Elmcroft and Tankersley Sawyer, it was a residential lease. It was a ground floor flat in London. And again, it's a short lease. So the only difference between this and commercial properties is the tenant's going to be, the landlord's the one who has to be responsible for repairs. And it was a badly designed or constructed damp-proof course in that it was beneath ground level. I'm no builder, but that's no place for a damp-proof course. And it was of no use whatsoever. There was large amounts of rising damp, and the rising damp would be sort of rotting the skirting board and the window frames, and also permeating the plasterwork, which was coming off. It's inherently defective, but that inherent defect has caused disrepair. It's caused disrepair for which the landlord is responsible for the woodwork and things and the plasterwork. And they went on to again, that's a impressive cough, but make sure that you're muted. Anyway, I won't tell you what happened in a course not so long ago when somebody accidentally unmuted themselves. But you can get the recording. It's probably on the dark web by now. But you could have, and the court went on to say that the landlord can't just do patch-up works. They have to go to the root of it and not just cure the obligations that they're responsible for, the woodwork and the plasterwork, but go to the root of it and replace the damp proofing. And that's the way you should think about doing it. Does that disrepair, does that inherent defect cause disrepair? And then it might just be within the repairing obligations. The Great Arthur House case is confusing, to say the least. It was actually long leases, 125-year leases. It was right to buy council housing buildings which had been built from the 1950s. And the court there said that it was inherently defective, albeit from 60, 70 years previously, in that it gave rise to water penetration, which had tried to cure for a long, long time. And the landlord was responsible for repair and maintenance, but could collect the cost via service charge. The curing of the defects would also give rise to repair. And the Court of Appeals said that it's still an inherent defect. The tenants don't have to pay for it. It's a bit of a policy case. And you've also got another case that is on page 1, I think. I've got different, don't ask why, but my printer's not working, so my page numbering might be a bit different than yours. But if I'm right, it's on straddling page 1 in 2 of the notes. You've got a very recent case, which you can see the Tower Hamlets case, Brewster House and Maltings House. I think it's a council house right to buy case, but it's incredibly significant for various reasons. It was the 1960s, early 60s, a couple of tower blocks and Tower Hamlets in London. And so you could equally apply this to commercial premises. And what had happened is it had something called large panel system, sort of cladding. This is not combustible cladding, but cladding does have a habit, even if it's not combustible, it has a habit of falling on people. And structurally unsound. Back in the late 60s, one or two of you might be old enough to remember, most will ask your great-grandparents. There was a disaster sort of predating kind of Grenfell on a block of flats called Ronan Point in 1968. There had this large panel systems, and several people were killed. And it structurally failed, or part of it structurally failed. And they, all over the country after that, again, a bit of a kind of precursor to Grenfell, high-rise buildings with this large panel systems were checked, by the landlords, not just in council house and flats and things like that, but commercial as well. And over the years, they started to try and remedy these problems. But after Grenfell, the landlord in this block, like landlords all over the country, went around checking their buildings. They found there were no fire safety issues, but there were still structural problems emanating from when it had been built, best part of 60 years previously. And so they had to do something about it. They can't claim service charge against the short-term council tenants, because of what we mentioned previously, it's a lease of less than 7 years duration of a dwelling. But they can claim against the people who've bought under right to buy. And the leases said that they could charge for repair and maintenance, and also there was a sweeper up provision. Anything else the landlord considers reasonably necessary for maintenance. And so they wanted to charge significant sums of money to the long leaseholders. And the court, the upper tribunal, decided to, basically they said that that's not repair and maintenance, it's an inherent defect. They did say controversially, I think this is a bit of a policy decision, that the sweeper up provisions wouldn't cover it. So if you can only charge via service charge for repair and maintenance, or if the tenant's only liable for repair and maintenance, it's much more likely than service charges that the landlord can charge for inherent defects because it says so, but not in individual lettings. But if it just mentions repair and maintenance, that doesn't include defects in design or construction. The one that's in the news, or has been in the news of late, a year or so back, if you remember, was reinforced autoclated aerated concrete rack. Do you remember that one? You know, it's found to be in schools, you know, at the start of the school year last year, and all schools that couldn't get back to school and like. There isn't a defined, well, there isn't a definition of inherent defects. That Great Arthur House case basically said so, and also that Ravenseth and Davstone case. Great Arthur House did say it included things like design defects and construction defects. It's not just, you know, sort of badly constructed. But there isn't one, you know, and that's what, you know, it's pretty fluid. A lot of the cases, without the benefit of hindsight, you don't know what they're going to say. But how can you make people liable for inherent defects? Yeah, that rack stuff is causing all kinds of issues in commercial premises all over the place, and also blocks of flats and the likes, not just in schools. Because unless the landlord can charge for inherent defects, then they can't pass the cost on. So how can you sort of do something? The problem here is a bit of, you know, degree level, not even land law, but tort law. The problem is you can't directly sue the person who's responsible, the developer or the designer, because it's pure economic loss. If you remember your studies, Murphy and Brentwood and Department of Environment and Thomas Bates, it's unless there's sort of damage to the person, imminent damage to person or damage to property, you can't sue in negligence. You can't sue the developers. So if in Department of Environment and Thomas Bates, it's been badly built, so it doesn't carry its design load or anything close, then you can't sue the developers or the designers. You can agree collateral warranties. They've never been particularly tested, actually, but I can't see any reason why not. You can agree a direct covenant with the developer, and then you can sue for breach of contract, and that's one way of doing it. But there's no sort of tort action. That's inherent defects. It's not just new builds, as we've seen, or comparatively new builds. And some of those cases go back to buildings that were built in the 50s, and the problems occurred 2 or 3 years ago. But you've got repair as opposed to renewal. On the bottom of page 2 and sort of over to page 3. The other issue, and it's not easy to actually sort of, you know, to sort of, you know, say which is which, is that if you are improving or renewing a building, then that's not disrepair. Repair means, as in that Lurkup case, you know, it was once good and it's now bad. You know, how do you define whether something's a renewal? Renewal is, as it mentions, restoring or replacing, you know, a substantial part. Repair is subsidiary parts, and that's not very easy. You know, I'll give you an example. It's not in the notes, but supposing you are gonna have to replace the roof, are you renewing the roof? In which case, it doesn't come within a repairing obligation, or are you repairing a part of the whole building? And you are almost certainly repairing a part of the building. But what if you're doing things like replacing or rebuilding an outbuilding? Is that repair or renewal? And that's much more dubious. In the more sophisticated leases, you should be perhaps making clear, you know, what constitutes repair and what constitutes renewal. I'll mention Mullaney and Craighead. They're again long leasehold flats. But again, bear with me, it should be exactly the same. And I've been mentioning these in courses for quite a while. And I think they're incredibly significant and brings in service charge as well. Mullaney, Maybourne Grange is in Croydon in South London. I've been mentioning this course for years, ever since I was a child lecturer all those years ago. But it's in Croydon. It's mixed use developments, 12-story block. And it's still there, just about. And they got wooden window frames. It was built in the 1960s, and throughout they've got wooden window frames. And the window frames are rotting away. They've got a service charge which says that they can charge for repairs and maintenance at the cost of repairs and maintenance to the service charge. And specifically, that includes the windows and window frames. A lot of the older leases don't deal with who's liable for the windows and window frames, and all that later. So they want to replace these, window frames and collect via service charge. And they think to themselves, this is not somebody pulling a fast one. They think to themselves, well, why would we replace like for like? We may as well replace them with more energy efficient. That's the name of the game at the moment. Window frames, UPVC. It'll cost a bit more now, but there's much less maintenance long term. And while we're at it, we may as well replace the single glazed windows with double glazing and cut down on people's energy bills. Again, the name of the game. And they wanted to go through the whole of this block, replacing the wooden window frames single glazed with UPVC, double glazing, and some of the tenants object to this and the tenants win. What you're intending to do is improve the premises, and if you don't deal with that in the service charge provisions, you can't improve the premises. And you can't charge anything. It's not just you can't charge the additional amount, you can't charge anything. And I've seen so many examples of that happening. For years, when I was mentioning Mulaney, years in the past, then people were asking me, what would happen if the same set of facts occurred today? Because in the world of resi, at least, in 2002, the most important thing ever in conveyancing, for some people at least, happened. And that's that fencer regulations came in. Some people seem to be obsessed by it to this day. With the exception of listed buildings and conservation areas, you can't replace like for like. You've got to replace by energy efficient windows, and that goes for commercial as well. So what would happen if there's an intervening statute that says you can't repair the premises? And that's what Craighead and Homes for Islington was about. And the court decided that if there's some statute that says you can't repair, it must be implied you can improve and add the cost of service charge. And the landlords won. And that is incredibly significant. I'll talk around this, and you might have questions about this, because I know quite a lot of commercial tenants at the lower ends are not sophisticated and don't want to pay you to negotiate these things. But that's one example, is fencer of an intervening piece of legislation. Lots of service charges, and as opposed to the initial lease itself, the lease itself, allow the landlords to charge for improvements and inherent defects, and add the cost of service charge. And we're going to come back to service charges later, but the landlord could potentially really go to town. I've given an example in the notes of R22s. You might not have come across them. R22s is another example besides fencer. They replaced R21s, actually. The R21A was a bit of a disaster. They were, or are, chlorofluorocarbides, CFCs. Again, the older members of the group, there might be some out there, will remember CFCs. They were a big story in the 80s. They're supposed to have been destroying the ozone layer. And they were found in, everyday items like aerosol cans and fridges, domestic fridges. They were found in industrial refrigeration units and air conditioning systems, massive things. They were banned by European legislation in 2004 for new systems. That's a long time ago now, but they could still be used in existing systems. You could sort of recycle the things until 2015. Time's passing on, but it's another example. Supposing you've got a multi-let premises and the landlord can, charge for repairs or maintenance and the likes, and suddenly the air conditioning system needs replacing, or the refrigeration systems, then according to Craighead, even if the lease doesn't say so, and lots of modern leases do, then the landlord could add the cost of service charge, and replacing by a brand new air conditioning system is going to cost an absolute fortune. And if the tenant's got 2 years left on their 54 Act excluded lease, the only winner is the landlord, and the tenant shouldn't have agreed that from the beginning. If it's an individual unit and the tenant's air conditioning or refrigeration system needs to be replaced and it can't be repaired because of legislation, the tenant's going to have to either be done for terminal dilapidations and not have an air conditioning system, or going to have to replace the huge expense, and the winner is the landlord. And you really need to think about that now. Lots of tenants will just say, get on with it, we hear what you're saying, and then complain 10 years later or whatever. But you really need to think about it, and think about caps on service charges, which if surveyors are employed, you can get the surveyors to tell you. You need to think about sort of limitations on the liability within the last year or two of the lease and things like that. And you're negotiating leases, commercial leases right now, not long ones, where by the end of that lease, who knows what legislation is going to be in place in relation to repairs things you can't repair, heating systems, lighting systems, ventilation systems. We don't know what they are, what they're coming. It's quite a frightening thing to think that what tenants might just be letting themselves into, especially in multi-let premises. And at least if they don't want to listen to you, at least think about protecting your back. I did warn you. You got any questions about that one? I thought it was quite interesting, actually. But anyway, there we are. I shall move on to page 4 and be a bit selective. I've mentioned that's the inset note, the effect on rent review. You can't just treat repairing obligations on their own, because they have a knock-on effect elsewhere. They can have a knock-on effect on break clauses. If there's a condition precedent, you have to comply with, reasonably materially comply with the lease and the likes. Tends to be the older break clauses. But I've mentioned Norwich Union, British Railway Board. A large railway marshalling yard, crew station to be precise. I was there only yesterday, and it hasn't changed since 1987. But anyway, it was a 125, it was a long lease, and they had to repair and, when necessary, rebuild, reconstruct, and reinstate. And they went through rent review based on, hypothetical letting, based on the existing letting, which is the sort of standard. And the court decided that, sometime in the next 125 years, you're going to have to be rebuilding and reinstating, buildings within this huge area, and that should affect rent review. And the consequence was there was a 27.5% reduction in the rental review. Now, in reality, if it's not predominantly review, which it almost certainly will be, there's no increase in the rent, but there's no reduction. But you shouldn't be getting something for nothing, so it should have an effect on that. And I would never, no matter who the landlord was, allow a landlord to change the rent review clauses to rewrite that. I've given you the possibilities. What might you think about, especially in the shorter leases? Not the 57-page leases of car parking spaces, but you could limit liability, internal decorative repairs. You need a schedule of condition. It doesn't have to be elaborate, but you need people in the high street don't want to pay for a schedule of condition and then give rise to disputes at the end of the lease later. You yield up in the same condition. Or I mentioned the Law Society's short form leases, which I don't think add anything, quite honestly, but you maintain the state and condition. Well, people really should be encouraged to get a schedule of condition. It's not a difficult thing to do nowadays. I don't know, people charge you for it. At least a few, photos and an agreement and the likes. I just came across one where they were bringing a claim. It was against the council, and they were basically told that you've got to show things. It's good if you can show mold growth and fungus, and they obviously misunderstood what was intended, and they produced some pictures of mushrooms in the place, in the premises, and they were just obviously from a punnet from Sainsbury's or somewhere, and they were just lined up in a row, these mushrooms, but they failed on that one. But anyway, and I've mentioned fire damage. I won't bother with the Fire Safety Act of 2021. We're going to come to the Building Safety Act in the last sort of 7 or 8 minutes, not much more than that. Normally, it's the effect of, well, normally, we said previously, repairing obligations do not require you to renew the premises. Unless there was reflected in the rental, you shouldn't be agreeing that. There are actually 2 exceptions. The major exception is fire. It's that Matthew and Curling case from the 1920s. If the property is damaged or destroyed by fire, the tenant is liable to rebuild. The other one is bomb damage, is the other one. It's a case called Redmond and Denton, like a bomb in the First World War. But that's why you have, or you should have, and you probably do have in standard leases, something to the extent that the tenant is exempted from reinstatement after fire, and the rent is suspended for X amount of time. Because otherwise, if there was a fire, the tenant would have to rebuild at their own expense. But then you'll probably have some other proviso to that, to the effect that, you know, the tenant's exempted from reinstatement after fire, except to the extent that the insurance is vitiated by the acts of the tenant or possibly people claiming under them. I would be so careful in relation to, well, the obvious thing, fire safety risk assessment. I've mentioned a bit of updating of the Fire Safety Act of 2021. But if the tenant hasn't had, for the individual premises that is, or implemented a fire safety risk assessment, you have to have them for the actual premises as opposed to the common parts only in residential, then they're vitiating the insurance. I talked to Aviva years ago when they were still Norwich Union. You know, basically what would happen if you didn't implement or have a fire safety risk assessment, and that's what they said, we'd reserve the right to refuse claims. You might just think to yourself how many people out there haven't, you know, tenants haven't had their risk assessments. Well, future landlords when the property's empty, because if you ask, you've got CPSE inquiries about it, you know, please provide the risk assessment, or where we may see the risk assessment, and you get the response, get your own done when you move in. You might have to get your own done when you move in because your needs are different than theirs. But if that owner, future landlord, when the property's empty, hasn't had a risk assessment and implemented it, they're vitiating their insurance. And you might ask in the high street, not the big time players, but in the high street, how many tenants have actually had and implemented risk assessments? I'd be amazed if it's 15%. And they could be required to rebuild the property if there was a fire and pay the rent in the meantime. And they'll default, and the landlord will have just an destroyed or damaged property, and they want to sue because they're not worth suing. I think people should be much more proactive. I did come across one where they definitely did, that the insurers refused insurance after a fire when the tenant had had a risk assessment but not fully implemented it. It was a fish and chip shop, which is a bit worse than most, I suppose. They partially implemented the risk assessment. They just started off in business. It's expensive to fit out the premises. They hadn't fully implemented it, and there was a fire, and the insurers refused the claim. And the tenants weren't worth suing, go bust without any money, and the landlords lost their premises. So I think landlords need to be proactive. You could start threatening forfeiture, and the tenants might just say, thanks very much for that, we're out. And 3 months later, you've got an empty property with business rates liability. I think landlords should actually do the risk assessments for those kind of tenants and charge them for it, quite honestly.
I hope you're enjoying the conference. Just wanted to quickly interrupt to remind you that LawSure provides these courses as a value-added service. We can only offer these courses free thanks to the support of our amazing clients. So if you get value from attending these courses and would like us to continue providing them to you for free, all we ask is that you support us by sending us your bespoke title insurance inquiries. That's all you have to do. It's a completely free service with no obligation to take out a policy, although obviously we hope you will. So you have nothing to lose and a whole lot to gain. And now back to the conference.
I've mentioned things about the premises subject to repair. Again, people don't want to pay you for this little service and thinking individually. Hence, we get all these sort of leases that, you know, you have to paint with oil-based paint the window frames when it's metallic or UPVC. But in terms of what the demise is, you know, if the tenant's responsible for their demise, then you might just think about, you know, who's responsible for shared walls and ceilings and the likes. Are they part of the demise or not? And if the tenant's responsible for the interior, what about layered floors? You know, are they within the interior? I've mentioned structural repairs. You've got a case on the bottom of page 5. Go on to page 5 on that. But on the bottom of page 5, there's a case called Granada Theatres, Freehold Investments of Leytonstone, where singly unhelpful, they talked about structural repairs, and they said that structural repairs might be anything but decorative repairs. This was replacing the roof, slates on the roof, and that was held to be structural repairs. Or it might just mean, if the tenant's responsible or whoever's responsible for structural repairs, just the load-bearing walls, the thing that gives it state shape and stability. Or it might just mean serious as opposed to, well, I'm not sure what non-serious disrepair is. But you need to think about, you know, have they really defined what structural means? And certainly in the old leases, you could say the same about residential. Some of the new besides. If there's one part of the premises where they don't define correctly, perhaps what is part of the structure and exterior, it's the external doors and windows. Hopefully they should be defined in the lease itself. And yeah, modern leases tend to, who's responsible. That Boswell and Crucible steel case said that if it's sheet glass, like you get in modern buildings, although this wasn't a modern building, that's where the windows are one and the same as the, you know, the wall, if you like, then that's part of the structure. If, according to Holiday Fellowship in Hereford, which is a bit later on, this is on page 6, sorry, told you my page numbering is a bit sort of awry. But Holiday Fellowship in Hereford said that normal's got a wooden UPVC windows in normal properties, if there is a normal property. They're not part of the structure and exterior. So if the landlord's liable for the structure and exterior and that's the cost of service charge, it wouldn't be covered via service charge. The best thing to do is make sure it is covered via service charge. You know, it's a lot cheaper for somebody to replace all the doors and windows and the likes all together than individually. That Fivers case, which I glossed over a bit, Court of Appeal case from Knightsbridge, said that unless you say otherwise, the front door was within the demise of the tenant, the front door of the flat. And they went all the way to the Court of Appeal on the basis that who owned the front door, so can the tenant paint it or not? That says something. And also, if you've got multi-let premises, you've got, you know, if it says the tenant's, you know, liable, you know, via service charge for the exterior, that probably just covers the exterior of that individual unit. Whereas what you should be saying, that's Camden Hill Towers and Garden, that's a case that's been litigated, that block from the 1950s build over the years. But what you should say is that, you know, there's liability for the exterior of the building of which the demise premises forms a part, is the way you should be dealing with that. And Douglas, Scott and Scorgie, another case. This would be unforgivable to miss, but one thing you don't want is the top floor, you know, tenant, be it commercial or long leasehold, residential, to be responsible for the roof. And make sure that even if the roof is sort of demised or the roof space is demised to the tenant, then the liability, you know, is the landlord's, and they collect from all the tenants via service charge basement and likewise, because that is fatal. And I've seen them, I'll tell you a story about it. And Douglas, Scott and Scourge said that if you don't say otherwise, and it's always subject to saying otherwise, if the tenant's responsible for their demise, well, if there's a void that the landlord's retained, an attic, whatever, then the demise is the other side of the ceiling. So the tenant might be liable for the ceiling, but they're not liable for the roof. If there's no void, or the landlord has, or sorry, not retained, the tenant's got a lease of the roof space, then the demise goes up to the heavens above, and that liability for the roof is the tenant. And that's not in anybody's best interest, including the rest of the tenants, because if the tenant can't pay for it or doesn't pay for it, it's going to affect the rest of the properties. Absolutely essential that you look for that. I used to live in Bristol before I moved to Cheshire. Well, I was in Bath as well, but before I moved up here to sunny Cheshire to be amongst the footballers and their wives, and I came across loads of properties in Bristol, residential, conversions and the likes, where you didn't deal with liability for the roof. Loads of them. And that should be an absolute no-no. And I've also mentioned the standard of repair pretty swiftly. But there are problems to be had here. Oh, I saw one with the roof space once, really, where the tenant had converted the roof space. It had an attic roof there on the top floor, and they converted it into an extra room and done a very good job, got building regs, and didn't realise until 8 years later when they sold that it wasn't their roof, it was the landlord's. That would make you sick. But anyway, the standard, Pride, Foot and Heart, one of the classic cases. The standard is dependent on the age, character and locality of the premises and the type of occupier. Sounds a bit snobby to me. It's not an easy thing to deal with, but if you've got a 300-year-old property, you've got a different standard of repair than if it's a 10-year-old property. And also the character and locality, that's supposed to still stand to this day, but do you live in the same area as the judge? That kind of thing, in which case it depends on those kind of things. And also the type of occupier. Mason and Total Finer Elf is a bit later on, actually, in the notes under damages on the last couple of pages. They said that in Total, the French oil giants, Total Oil, and they were the tenants. And the court said that if you're a large multinational, you've got a different level of repairs than if you're not. If you're just some everyday corner shop, you'll have a different standard of repair, but it's very difficult to deal with. And people forget this, and Strudgoff, Calthorpe and McCosker, Calthorpe Estates. The standard is that which applies at the time the lease is entered into, and not today. You have to build up to the standard of when the lease was entered into, what would be considered satisfactory, which is an issue if you've got something like a new build property, because you're supposed to build up to the same standards, or repair, I should say, up to the same standards as when it was new, and not sort of 25 years later. And that's got drafting implications, actually, and we haven't had many questions today. But it's got drafting implications for subleases. Supposing you've got a new build property on a 25-year lease, and after 15 years, they sublet for 5 years. And you just tend to repeat the same repairing covenants, the same covenants in the sublease as the head lease. And it's a different standard of repair because it's now the standard for a 15-year-old property. So the tenant might find that they haven't actually covered themselves. And you've got postal and boots. The landlord can rely on a reasonable surveyor on page 9, that is. But we'll go on to, well, I think it is. We'll go on to the next page. I say, I think 5, 6, it's page 7. Sorry, I can't read my writing. It's page 7. We'll go on to page 8. Cases on service charge liability. I'm not too bothered about the first paragraph, but I am bothered about Sara and Hossein and Blacks. I was mentioning this in the course to one of you, or possibly more, yesterday. I've been mentioning it in updates and the likes on page 8, and it's incredibly significant. You got the Court of Appeal case from late 2020 and then the Supreme Court case from early 2023. And you need to absolutely make sure if you're dealing with service charges that you deal with this. I know the very property. It's in Liverpool. It's Black's Outdoor Clothing. Last time I saw it, it was boarded up. It's in the middle of Liverpool. I did hear it was going to be converted into flats, which surprised me. But it's one of, I became aware in a course yesterday, actually, that how many of these cases involve properties that I know and probably visited at some stage in the past. I did mention to some of you before, but I'm actually thinking about some guided tours for tourists with a property related slant. So we could go around Liverpool. London's the place for it. Go around Liverpool and I could show you here's where there used to be Black's Outdoor Leisure, and this is the background law to it. So if you want to sign up to that, do feel free. You could do it by foot, I'll just have an umbrella. But Sara and Hossein, Blacks were the tenants, and they had a service charge liability, and they had an estimated service charge, and then at the end of the year there'll be an actual service charge, and certificate. And it says that I'll come back to the question in a minute. There's one other thing I should have actually mentioned in private, so I'll come back to this after this case. They said that the certificate was going to be conclusive both as to the amount owed and also whether it was covered via service charge, both itemised works and total amount. The tenant objected to the fact that one year the service charge was 55,000 and the following year they wanted 400,000. And that's what the case was about. And the Court of Appeal said, you've agreed that it's conclusive, both as to the amount and also the itemised works, whether it's covered by service charge. And you can't object unless there's fraud or it's manifestly wrong or mathematical error. You have to pay the money. There's no ability to object. It went to the Supreme Court, and the Supreme Court, with one big proviso, agreed with that. The landlord gets their money unless there's fraud, manifestly wrong, or mathematical error. They said that what then can happen if the tenant objects and thinks the service charge liability isn't due, they'd have to go to court for a separate action, under a separate action. But they have to pay the money up front. And high street tenants are not going to be able to go to court for a separate action. I'll come back to the Anstruther case that somebody's mentioned when I've gone through the service charge case, but I will come back to it. Like I said, the high street, they can't do that. The good news for landlords is they're guaranteed their money. You must deal with that. This last couple of years, you've started to deal with that dispute resolution clauses, and you must make sure if you're acting for a tenant, there's some sort of dispute resolution clause on the service charge. If you've got a residential property, there's huge amounts of statutory control of service charge, massive amounts of statutory control of service charge liability. The Landlord and Tenant Act from 1985 as much amended, and it's going to be amended again in the Leasehold and Freehold Reform Act provisions coming next year. The work must be reasonable standard, reasonably incurred. That you must go through sort of consultation galore before you can charge tenants more than £250. There's absolutely no statutory control of commercial properties. I'd want a reasonableness test. I'd want certainly some sort of arbitration. I'd want to think about service charge being based on floor area and caps on service charges, which you need surveyors to tell you what they should be. But don't let that go through without warning the clients. It goes back to what we talked about previously in those Millennium Mayborn Grange and the UPVC double glazing and the likes. That clause could require tenants to pay an absolute fortune in the future in relation to energy efficiency. The Anstruther case, the standards, the commencement of the lease. I mean, it causes problems when there are subleases, but yeah, it's at the commencement of the lease. I think you should always have a schedule condition. Proudfoot wasn't too much of too objective because it depends on the character of the premises and the locality and the nature of the you know, the occupier. The other thing that Proudfoot said, that I should have said, but I'll go in a minute, is that if you've got a covenant to put in repair, then that requires you to put good any disrepair at when the lease is entered into, which, unless you're being charged much less rent, you shouldn't be agreeing. But if it's a covenant to keep in repair and it's in disrepair at the beginning, that requires you to put in the repair as well. And you should always be prepared to spot that, because you do see them. You'd be liable for any disrepair. The schedule of condition would be useless for you. In general, would the landlord be responsible to carry out any necessary improvement works and pay for such costs in order to comply with the EPC rating? The problem with the legislation is that, with the minimum energy efficiency standards and the likes, is that the landlord's the one who's responsible to make the property whatever energy rating might be in place at the time, because it's probably going to go down from E rating. When, we don't know. But it definitely will go down. There's nothing that stops the landlord adding the cost to, you know, the tenants. And you've seen for years leases that require the tenant to pay for the cost of any energy efficiency. I'd resist that as a tenant. It's arguments put forward that the landlord wouldn't need to have something expressly there, because they could do it within the statutory compliance provisions. The tenant has to comply with statute. In a perfect world, I'd want that rewritten and make it clear that the landlord is responsible for any energy efficiency works. But I better move on. I'll go on to the next page. Briefly, some other considerations, not least of which the length of the term. Short-term excluded leases should not be entering into full repairing obligations. And on page 9. But if it's a 54-hour protected lease, that Omey and City of London Real Property Company says that, you're supposed to have regard to the terms of a current tenancy when you go through a lease renewal. So you shouldn't be changing the repairing covenants unless it's very, very exact circumstances. So if it's a 54-hour protected lease, it's probably more likely that you should be agreeing full repairing, but not full repairing, and not sort of tenants doing the energy performance work on a shortish excluded lease. Landlords try and sell it on the basis that you'll get reduced energy bills. It's in your best interest, not if there's only a year left on the lease. But anyway, I've got a few other things to look forward to. We've mentioned service charges and extensive repairing obligations and the effect on rental. And there's not much on page 10 of the notes. And we'll go on to page 11, and briefly, because I wanted to say a little bit about damages. The Building Safety Act. The worst drafted legislation I've ever come across, as I mentioned in the Times and Sunday Times when I was quoted. Now you're impressed. But I'm never tired of mentioning that. Anyway, I've mentioned a bit about higher risk buildings and then damages, and then that'll be time to finish. This is not Wales for anybody doing work in Wales. Wales are not bringing the occupation stage for high risk buildings in, and they're not bringing the leaseholder protections into force. They say they're going to have their own Building Safety Wales bill introduced before the next Welsh Assembly elections in May 2026. So just England. Higher risk buildings are ones with at least 2 residential units in them, and they're either 18 meters or 7 or more stories in height. One problem you've got with that definition, just like the leaseholder protections, I'll deal with this in the context of mixed use premises because it's 2 or more residential units, it could be mixed use, or if you're buying the reversion for that matter. One problem you've got with that is the deciding on the height of the building. There was a case about a year ago, it's not actually in the notes, called Wait and Could I. This applies, let's say, to leaseholder protections where it's 5 stories or 11 meters, where the first time they measured, the surveyors measured the building, it was 17.57 meters or something. The next time they measured it, it was 17.93 meters. It had grown with a margin of error of 30 centimeters, which made it more than 18 meters. Then they decided you're supposed to measure from the lowest part of the ground floor, not to the top of the top floor, but to the floor of the top floor. But it was mixed use, and it had a communal roof terrace. And they decided on the definition that the roof terrace was actually the top of the top floor, which brought it well beyond 18 meters. I've seen premises flats with 4 stories and a ridged roof. So they don't look like they've got 5 stories, but the ridged roof was used for storage. That's a 5-story building. And so you don't really know. But that's the basic idea. And the Royal Institution of Chartered Surveyors told their members not to cooperate as a consequence of that. But suffice to say, all higher risk buildings in England should be registered with the Building Safety Regulator, which is part of the Health and Safety Executive. The registration started in April of last year. They had to be registered by October the 1st. And if they weren't, somebody called the accountable person, the person responsible for repairs of the common parts or interest in possession of the common parts, is committing a criminal offence. The register is a public document. It's not accurate. I've seen buildings that claim to be 18 meters in height and have 16 stories, so that doesn't give you much space. And it is very inaccurate, but you can go on the website of the Health and Safety Executive. I wouldn't dream of buying a flat, and I wouldn't dream of taking on a commercial use in a higher risk building unless it's been registered. And it mentions somewhere that section on that page mentions somewhere section 112 of the Building Safety Act. If you've got a higher risk building, there are implied terms in the residential units. In that you should cooperate with one another. And these are contractual terms. The landlord has the right on 48 hours notice at a reasonable time to enter and inspect in relation to safety. They've got a right in relation to safety to tell the tenant to improve the premises or do it for you, or alter the premises, change the doors. That's just residential units. If I dealt with a property, a high risk building, commercial unit, I would look at section 112, I'd adapt it, and I'd put express terms in the lease. Pointless if you have to inspect and alter the residential units if you don't the commercial. And they changed the CPSE just over a year ago. You've got the CPSE 1 version 4 inquiry 15, which I'll leave to you, but I'll go on. It's 12:15, so I better tie things up. On to the last pages. It's under the heading of damages for disrepair, the last couple of pages. Very briefly, won't take you much longer. Section 18 of the 27 Landlord and Tenant Act is the thing that says the landlord can't sue in damages for more than the diminution in the value of the reversion. And if you've got substantial works planned on the premises after the lease comes to an end, you can argue, if you're going to demolish it, there's no diminution in the value of the reversion. Drummond and S&U stores, the tenant left the premises. It doesn't apply to tenants' liability. It's just, the tenants' obligated rights against the landlord. But in Drummond and S&U stores, there was a shop front which had been left in a state of decay and disrepair. And the court accepted incoming tenants are going to want to put their own shop front on. And so there was no damages. And I'll mention the last case in the notes on page 15. That Hammersmatch case, St. Gobain Ceramics, 1930s property, sort of outstaying its welcome in life. It was a lease from the 1980s, a long lease, and the tenants before the end of the lease had just vacated and left it in a perilous state. And the landlord was claiming huge amounts of damages. They got a fair amount. It was assessed on the basis, the last few lines of the last page, that the value of the property when reinstated was 3.061 million. The current value of the property in a state of disrepair was 2.1 million. For some reason, they rounded it up, so damages were 900,000. That was an eighth of what the landlord was claiming. Because it's a 1930s building, you want to do substantial works on it. But it's gone 12:15, so unless you've got, don't forget, you can contact me as it says there on LinkedIn, and you can hear my witty stories. As a consequence, I haven't posted anything for a couple of months, actually. I shall have to do something. But anyway, thanks a lot. Do sign up for the client exclusive. What's the date, Mandy?
It's the 24th of October. It went out during this conference and we've already had a very large number of sign-ups. So thank
So
you.
it's going to be it's going to be Oasis all over again then.
I think it is. And thank you for those who have already sent some inquiries in as well during this conference.
Okay, thanks. And we'll be here for the normal courses sometime. I can't remember when, at the
Beginning of November, the topic yet to be decided.
You have been listening to another conference hosted by LawSure Insurance, the UK's leading specialist broker for title insurance to support conveyancing transactions. Help us to help you. If you have a transaction that needs a title insurance policy, contact us now on 0345 557 0845 or email conference@lawsure.co.uk. Our service is completely free with no obligation to take out a policy. Contact us today. Why wouldn't you?